In all lands, Your Lordship. There is no agriculture.
These lands have been converted from agriculture to
No, no, no.
non-agricultural use.
There is house construction is there. Suit is pending in page number 22, Your Lordship.
Yes, right. And this repetition is filed questioning the notice issued in file number, impugn notice issued in file number A3/08/2025, seeking to conduct the survey of the lands in survey number 739. Mr. It is stated the lands in survey number 79 or 739 or in all other survey numbers.
All other survey numbers are there.
It is stated that you are a owner of survey number.
Yes, sir. 739, Your Lordship.
It is stated the petitioner is owner and possessor of the various extents of lands in survey number 739, having purchased under registered sale list by document number 7879 of 2012, 4732 of 2015, 4733 of 2015. It is stated when the dispute arose, when the respondents, when the seventh respondent disputing title and ownership over the property. You have instituted the suit.
Yes,
The
sir.
petitioner has instituted suit for.
Suit for injunction, Your Lordship.
Petitioner has instituted suit for an injunction.
I'm sorry, seventh respondent has been initiated the suit.
Yes. Emana? Disputing right and title of the petitioner, the seventh respondent has instituted the suit for their injunction, and the same is pending for adjudication. Pending adjudication, the seventh respondent, instead of taking pending adjudication of the said suit, at the instance of the seventh respondent, the respondents are seeking to conduct a survey of the lands which are seized to be agricultural lands. Lands which are seized to be agricultural. The land council appearing for the petitioner vehemently contended that the survey department is not having any power or authority to conduct the survey of the plots which are no more agricultural lands, and even any plain application submitted for conducting survey in circular as per the circular instructions are not applicable for non-agricultural lands. These issues are required to be examined only after filing of counter credit. Meanwhile, in the said circumstances, in view of the said submissions, there shall be interim suspension of the impugn notice dated so and so, and the petitioner is permitted for a period of 4 weeks. Petitioner is permitted to take out personal notice and post after 4 weeks.
Declared.
Lordship, on behalf of Raju Advocate. Lordship, the petitioner is challenging the impugned order at page number 18.
Page number 18.
18 of the material papers, Your Lordship. Issued by Collector, Court of the Appellate Tribunal, come District Collector and Magistrate, Hyderabad District, Your Lordship.
Yes.
This is challenged on the ground of non-consideration of principles of natural justice, Your Lordship. Your Lordship, the Collector passed order against the respondent alone, Your Lordship, without issuing notice to all other inmates of the house, which is mandatory under.
See, according to you, not only the petitioners are all of the children of the
Petitioner number.
fifth respondent.
Yes, Your
Tarabai.
Your Lordship.
Therefore, nobody wants to maintain the senior citizen.
No, that is not my case. I am ready to maintain the
See,
city.
there was an observation concurrently by both the original tribunal as well as an appellate authority. So, scope of the judicial review to entertain the appeal, the repetition, and reappreciating evidence is very limited.
Exactly.
See, if you are having case, we also know how to deal with the senior citizens case. Therefore, in a judicial review power, I am not supposed to examine the evidence being examined by both the courts and come to a different conclusion basing on the evidence. Therefore, you have not made out any case.
One submission.
It is your moral obligation, it is your wife's obligation to maintain your mother at the age of 71 years. And
I'm not denying
children, you don't want to maintain your mother.
I am not denying you, Lordship. My humble
Then
submission
why you
is
filed, if you are not denying, why you filed a repetition before this court?
the collector passed an order.
Collector has rightly passed an order.
No, Your Lordship. Your Lordship may kindly come to page number 17 where law says that.
What law says?
Your Lordship. Page
Law
number
says that
17.
senior citizens has not to be maintained by their children. Show me that any what law says it.
No, the law says, Your Lordship, the collector and district magistrate during summary proceedings for the protection of senior citizen parents shall consider all the relevant provisions of the Act. If the collector and district magistrate is of the opinion that any children legal heir of a senior citizen parent is not maintaining the senior citizen parent and are ill-treating him or her them and yet occupying the property of the senior citizen parent and that they should be evicted.
Only the mistake committed Mr. Subhas by both the authorities is They have not passed an order immediately throwing out you from the premises being occupation of the senior citizen.
Your Lordship,
If you want, now I will clarify the orders of both the
my
authorities.
my
I will
submission,
direct the police to throw out you immediately from the premises.
Your Lordship, my submission is,
Just this order before the appellate.
Your Lordship is well aware, Your Lordship,
I am
where,
aware. I am saying that
My-
not only I am aware, you are also well
Yes,
aware
Your
being the senior citizen. Now you have also crossed 60 years.
my humble
knows the
submission is
difficulties
kindly
of the senior citizen.
remand the matter to the collector for fresh
No, no,
consideration, following the rule, Your Lordship, following the
Mr.
rule.
Counsel,
Rule is there.
It is not for you to ask for the relief. It is for the court to consider for granting of relief. It is for me to grant a relief basing on the facts. You are not supposed to ask remand me, set aside the order. You are only entitled to your argue to the case and give it to the court.
Your Lordship, the collector did not follow the procedure contemplated under Senior Citizen Act and under Rule 2, Your Lordship.
There is no procedure. Procedure is only to hear the parties and.
That's why my submission, Your Lordship. The petition number
You want to-
225 are not here, Your Lordship. That is my submission, Your Lordship. The collector has mandatorily issued notice to all the inmates of the house, but he did not do so, Your Lordship. Only one person has been given notice, that to order passed ex parte, Your Lordship.
What is the order? Read the collector order.
Collector order directing the eviction of the
Read that order, collector order. Which is at page number?
page number 18 and 19,
Yes.
20.
Read that findings.
Findings, Your Honor. Upon receiving the petition and the material presented, the adjudicating authority verified the report submitted by the RDO Secunderabad as per Rule 21 3A. It was established that the property was purchased by her father, late Anandam, administering 320 to 20 square yards, bearing survey number 115 by sale deed number 1028 by 90, dated 24/4/90. Since then, she was under possession, and the respondent, Mr. Naveen Nayak, her daughter-in-law, Mrs. N. Sujata, and their family had no legal right to occupy the property. The collector himself admitting, Your Lordship, the
No, read what is that order. It is only finding, he says. You should know.
Basing on these findings, based on the-
Stop reading when impugned orders.
Your Lordship, based on the evidence and testimonies presented, the adjudicating authority ordered under Rule 21(3) of the TMWP-SC Rule 2011 that Mr. N. Praveen Nayak and his family must vacate the petitioner's property, residence of house number 115, Tara Nayas, Big Said Road, Third Band, Secunderabad, within 30 days from the issuance of the order. Consequently, the applicant has the freedom to make decisions regarding the said property as per their will and wishes. If she needs maintenance, the applicant is advised to file a maintenance application with jurisdictional RDO. The case is hereby dismissed. My humble submission, Your Lordship, may kindly observe the collector under order saying that his family must vacate the petitioner's property, whereas he did not issue any notice to those family members as per the mandating rule, Your Lordship. Rule 4 is mandates, Your Lordship. The magistrate shall issue in the manner herein after provided notice in writing, calling upon all persons concerned to show cause, Your Lordship. But in this case, the petitioners 2 to 5 are not given any notice.
Your mother is residing there.
Mother is residing outside, Your Lordship. Moreover, I am ready to maintain.
No, I am asking you why she is residing outside.
She is alleging some allegations against the petitioner, saying that they thrown out her.
Then you vacate and hand over the possession of the property to the mother, because she is also one of the shareholder of the property of her late husband.
I am ready to accommodate my mother with me, Your Lordship.
So who are you to accommodate? You are not doing any favor to your mother by accommodating.
No,
You are enjoying the property of her late husband. See, you are not the owner of the property. You are only one of the shareholder of the property by virtue of her husband being expired interstate leaving any will. Therefore, she is also one of the shareholder.
I am ready to.
You are not doing any favor to your
I am
mother.
not doing.
Then give a property to third party also encroacher. He will also maintain your mother. What is that you are doing favor to maintaining your mother? It is a pious obligation on your part to maintain your mother.
Yes, I am ready to maintain, Your Lordship, but my humble submission is.
Don't say any humble submission. Your humble submission has been shown from the seeing of the record itself. Don't take an advantage.
Tomorrow, I don't want to. I don't want to raise.
Don't take any advantage of the technicalities. It is a beneficiary legislation. The prima facie, if it is only on the ground that they have not issued the notice,
Notice,
I am
that is
interfering. And this repetition is filed. The questioning the orders passed by the district collector as an appellate authority under section 22(2) of maintenance of senior citizen Adantarayam, read with rule 22. The petitioner, the respondent number so and so, who is the senior citizen and mother of the first petitioner, and mother-in-law and the first petitioner has filed a application, filed a case by case number A/825/2024 dated 3/1/2025 under section 22(2), seeking eviction of the petitioners and other family members from the premises in occupation, from the premises bearing house number 115, Tara Niwas, Brick Sai Road, Carbon, Secunderabad. Mr. The district collector, having examined the report of the revenue divisional officer and after verification of the records, has come to conclusion that the said property has been purchased by a late husband of the sixth respondent under register sale deed by document number 1028 of 90, dated 24/4/1990. The grievance of the petitioner is the respondent district collector, without issuing any notice, as required under the rule
Page 17, page 17 notice was issued, lad. Within 10 days, you fail, your matter will be decided on ex parte. Page 17.
The district collector, after issuing of notice,
Rule 3,
as per proceedings number 8, the notices would be issued only to prima facie informing you a case has been filed against you. Please come and contest the matter. దాని కింద కామా ఉందా, ఫుల్ స్టాప్ ఉందా, నోటీస్ ఉందా, ఇది కాదు ప్రిన్సిపల్స్ ఆఫ్ న్యాచురల్ జస్టిస్. వెదర్ ది నోటీస్ ఇండికేట్స్ కేస్ హ్యాస్ బీన్ ఫైల్డ్ యువర్ మదర్ ఆర్ నాట్ ఇస్ ది ఇష్యూ. దట్స్ ఆల్. What
but
do you want?
the law says notice has to be issued to all the inmates of the house.
Educate this law before the Supreme Court. Supreme Court will lay down correct. Yes.
Rule 3, 4 is.
Don't argue on technicalities, more particularly when this is only after independence for the senior citizens. It's only such an enactment which has been enacted at least for the senior citizens. లేకపోతే యూఎస్ లేనట్టయితే మన పరిస్థితులు కూడా రేపు పొద్దుగాల అర్థమైంది దాటినాక. ఇప్పటికే సీనియర్ సిటిజన్స్ హోమ్స్ వచ్చేసినాయి హైదరాబాద్ చుట్టుపక్కల, తెలుసా నీకు? ఒక 3 ఏళ్ళు అయితే అంతా గుంజుకొని వెళ్ళకూడదు ఇళ్ళలోకి వెళ్ళి పోరలు. కీప్ ఇన్ మైండ్ వాట్ ఈస్ హ్యాపెనింగ్ ఇన్ ది సొసైటీ. After issuing notice in proceedings number A/825/2024 dated 24/8/2024, as there was no response to the said notice, he issued the notice to the petitioners, and as the petitioners have not turned up to contest the said matter, relying upon the report filed by the revenue divisional officer, passed in orders of eviction. Mr. Prima facie, the procedure adopted by the respondent for passing an eviction, ex parte eviction, that too without providing a reasonable opportunity. District collector passing an ex parte order and evicting the petitioners who are in question since long time, and who are also claiming the the rights over the property of late their father of the first petitioner. Correct. Second petitioner wife female. మిగతా వాళ్ళంతా గ్రాండ్ చిల్డ్రన్. ఫస్ట్ petitioner husband. Who are also claiming the rights of the property, having success in interest of the late Lord Singh. These issues are required to be examined after finding a counter by the fifth respondent. Pending examination of the said issues, there shall be interim suspension of the interim order, subject to the petitioners paying an amount of rupees 25,000 towards monthly maintenance, by paying an amount of rupees 25,000 towards maintenance to the sixth respondent on or before 5th of every month, and failing such to deposit the monthly rent as directed above, the stay granted by this court deems to be vacated. If you failed on or before 5th of every month of 25,000 to your mother account,
Yes.
the stay granted is deemed to be vacated. There is no necessity of filing any vacancy also. Yes.